This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking calls and questions answering about fighting the insurance company. Life is full of hazards and something's going to happen to you at some point, whether it's an accident on the interstate or a fire at your house. That's why we all have insurance. But what happens when the insurance company is giving you a hard time? Maybe they're pressuring you to sign a quick settlement. Maybe they're not being reasonable in the amount. Maybe they're dragging their feet. So what are you supposed to do about that? Tonight, you're going to find out. Tonight, we're talking about fighting the insurance company and answering questions. And you can send in an email question, too. You can send in an email question on any legal topic any day of the week. You send it to lawcall@waytv.com. And when we get to a show that's on point, we pull some out. We've got some of your email questions tonight. We've got with us Will League and William Meservey, both from Timberlake and League, answering questions about fighting the insurance company. And you guys fight the insurance company all day, every day.
You know, I would say 100% of the cases we handle, but you know, William and I, we run across 98, 99% of the cases we handle. Ultimately, we're fussing with insurance companies, whether it be truck, car wrecks, medical malpractice, workers' compensation, premises liability, even the mass torts. When you talk about the earplugs with the military or the burn pits, or talcum powder, it always ends up with an insurance carrier or some type of fund that are making the calls. For example, Sharon, Will League runs into Sharon Doviet, it's my fault, y'all file a claim against me.
Yeah.
It's Sharon Doviet versus Will League,
yeah.
And the jury is not entitled to know that there's insurance coverage behind me, and they're the ones making the call. Even if I said, look, I was drunk, I was speeding, I was steering with my feet, my head was out the sunroof going 100 miles an hour, the insurance company, not me, makes the call as to whether or not we can resolve that case. And so most of the time, William and I are fighting the insurance company's lawyer, even though they're hired for the particular defendant. To be honest, their real client is the insurance company, and oftentimes we can get those cases resolved, but oftentimes we have to file and go through the litigation process and ask a jury what they feel the case is worth. But again, the insurance company makes the call. You know?
Okay, so William, why is it that they would not want, I'm assuming it's an insurance lobby, why would they not want it to come out in a trial that there's insurance to cover this?
Sure, so their argument, and it was successful obviously, was that it'd be prejudicial to the jury to know that insurance is involved, and that a jury would be much more likely to bring back a verdict if they knew an insurance company was involved versus if they thought it was an individual and that the individual would have to pay that out of pocket.
Gotcha, okay.
Well, William, on the other side, and I know you're not with the insurance company, and I get it, we're on the same team, but on the other side of that, but that's not true.
It's not.
The little old lady that hits you on the way home from church, she is not writing that check if she kills your daughter or damages your vehicle or any of that. It's not the sweet little old lady on the way home who was in an accident, made a mistake. It's the insurance company, and so it's really prejudices the claimant in this process, and there's no surprise the insurance lobby in Montgomery is more powerful than the consumer side, and they got this pushed through, and it really harms Alabamians who need help in the judicial system. And it's just plain, it's wrong, it's a lie, and it's not right, but that's sadly the law in Alabama.
Changing? It's not changing, is it?
Write your legislature. Let's, maybe.
Okay, we've got an email question. This one is from Paul. Paul says, once I reach a settlement agreement with the insurance adjuster, can I trust their forms? How much would an attorney charge to take a look at the paperwork and just tell me if it's legit? Is that something a lawyer would do for you?
William and I had a case just last week. So we get a release in, we go over it with our client. There are several provisions in there that you have to be cautious about. And remember, anytime you're resolving a claim, it resolves it full and final, unless it's workers' compensation to keep your medical bills open. But most of the time, without exception to workers' comp, that releases them from all liability now until the end of time. So if you haven't finished your medical treatment, if you don't have all your bills in, and you don't have all your damages calculated, then you could resolve your claim and still have to pay out further for the damage caused by the defendant. And there is an indemnity provision in there which is very troubling. William, tell us about if you have a subrogation or indemnity provision in a release and you don't have a lawyer, what's the deal?
So indemnity is a fancy legal word, but essentially what it means is you're going to be an insurance company for the insurance company, right? So what indemnity means, when you indemnify someone, it means that should there be an issue down the road, if someone were to come after the insurance company and say, hey, this medical bill went unpaid or whatever it was, they're saying that when you sign that release and you sign that indemnity language, you're saying that you will not just release them from any liability, but you will pay to defend that claim. You will pay to defend the insurance company from any possible potential claim against them. So it can be hazardous to sign language like that, and particularly if you're not sure that all the bills have been paid.
Yeah, so how that works in reality is client comes in, hey, I signed this release, I didn't feel like getting a lawyer, but it was a property damage issue, didn't think it was that big a deal, and I indemnified them. Well, in this particular wreck, there were three people involved in the wreck, 2 victims. All of a sudden, the client that came in to talk to us had signed this indemnity provision. The defendant is being sued by the other driver, and the other lawyer is arguing that indemnity provision, now you were the victim in the wreck, but now you're in the shoes of the tortfeasor or the one who caused the wreck for this other driver.
And they've turned in the papers.
They've turned in the papers, they signed the release, there's an indemnity provision, and now all of a sudden not only you don't get a recovery, but now you've got to pay for the defendant. So you can step in it real fast if you don't know what the language is on those releases. So whoever emailed this in, hold off before you sign that release. Get legal advice before you sign it, because it can be no joke.
The thing about releases is once you sign it, once that release is signed, there's no way to undo it. And so, we've seen this before where someone says, hey, I thought my neck was just sprained. They offered me $3,500. It seemed good at the time. I signed it. But you know what? My neck pain never went away. And I ended up in an orthopedic surgeon's office. And now I need neck surgery. What can I do? And the answer is nothing, because you signed a release releasing them from any and all liability as it related to that particular incident, to include future medical. So, you need to be certain before you ever sign a release that all your damages have been covered.
Sharon, there are different levels of adjusters. Once you're in a wreck, there's the first line of adjusters will be calling you. It's kind of good cop, bad cop. Call you, let's get your car fixed. Let me get you a little money for your pain and suffering. And sometimes clients are like, hey, great, thanks so much, you're so helpful. Well, if it rolls on past that, then all of a sudden they transfer it to a new adjuster who's not so nice.
Yeah.
And so the reason they get to you quick and fast to try and resolve your injury claim, and if you don't take that first bait, and then it switches it to another adjuster and they're a little more difficult, and because the claim has a lot more higher value. So just be careful when they're sweet and nice and, hun, we're gonna take care of this, and just here, sign these documents. A lot of clients come into William and I and have pretty much signed their case away, and there's nothing they can do. William's exactly right.
Trust no one. Okay, we've got callers with questions. Carolyn's on the line with a question. Hi, Carolyn, thanks for calling. What's your question tonight?
I was hit from the rear by a car and a truck. The truck left the scene, and so they were not able to, the insurance company was not able to recoup monies from him, and neither the car that hit me directly, so he says, because he said the truck hit him. But long story short, when my insurance renewed last month, my insurance actually had gone up $600 because I have my home and my car both insured, and the two combined had gone up $600. Can they do that?
This accident wasn't even her fault. Can they raise her rates?
William, what do you think?
Well, they're not supposed to raise your rates if you are not at fault for a wreck, right? But there are a series of rate increases they can do and allege that they're unrelated to this wreck, right? The cost of claims in your geographic area have gone up, and we're assessing you some sort of, penalty with relation to that. But, the reality is if an insurance company pays, and so what would have happened in this situation is Carolyn would have had full coverage, I'm assuming, and because of that, her own insurance carrier would have paid to fix her damages, because one of the vehicles that was responsible for this was a phantom motorist, or a vehicle that didn't stick around, and the other vehicle was uninsured. And so her own insurance company has paid out money on her behalf. Typically, your own insurance company will then go back against one of these other carriers through arbitration, or in the event that driver was uninsured, like in Carolyn's case, then they may choose to sue that individual and go after that individual for every nickel they paid out on behalf of Carolyn. And so, you do see that from time to time, but the reality is insurance companies do not like to pay money out not be able to recover it one way or another, right? And so in this instance, they may be trying to raise her rates to try to recoup some of that money.
You know, and I hate to say that we don't know the answer, but with regard to how the Wizard of Oz behind the curtain does his thing, the insurance companies raise their insurance rates on a very arbitrary situation. In the caller's case, it was a no-fault claim, meaning the injury and the damage was not her fault. It was clear. It's on the police report. They were unable to make a recovery against subrogation, what we talked about earlier. They're unable to go after the at-fault party, and they raised her rates. There could have been another reason that they raised her rates, but them raising it for an at-fault or she was not at fault is wrong, and I think against the insurance policy. Now, if you call them on it, they're going to say, well, times are tough, and it's across-the-board raise, and so you're welcome to find another insurance company. And if all of them are raising your rates as you go, where can you go? I think there's collusion against with the insurance companies. I know I'm throwing that out there, but lawyer malpractice, medical malpractice, those insurance rates are rise, and they're not a terrible amount of successful claims. So the insurance companies, they're a big bad bully, to be honest with you.
And I bet even if she shops around to apply to a new insurance company, they're going to ask her what claims she's made lately, right?
That's right.
So you can't even
And
can't hide that way.
A no-fault claim shouldn't hurt you when you're going to shop for new insurance carriers.
Okay.
Now, no insurance carrier will pick you up while you have an open claim.
Okay.
And so she'll need to finish that claim out with her insurance carrier, but then she would be free to explore other options, and that's not going to show as an at-fault wreck on her record.
Okay. They're telling us to take a break. We're going to have more calls and questions coming up. Stay with us. We're going to talk about fighting the insurance company. Be right back.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Doviet. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back. I'm attorney Sharon Doviet. We've got with us Will League and William Meservey, both from Timberlake and League, attorneys at law, and they practice fighting the insurance company all day, every day. And we've got callers waiting with questions about that. We've got Dana on the line with a question. Dana, thanks for calling. What's your question tonight?
My son was asked to help split some logs on personal property by a gentleman, and he would pay him for helping do this since the gentleman, that's the way he made some of his money, selling the firewood.
Okay.
And while my son was there, he got his thumb crushed. And we had to take him, obviously, to the emergency room. He had to have his thumb put back together. We obviously have a lot of medical bills from that, and he was not able to work for like 6 months. After that, we didn't know if he was going to be able to keep his thumb or not. And I'm wondering, is this gentleman not liable for these medical bills?
A couple of things. Depending on the status that he was helping him, may have been an employee. Now, if this employer had 5 or more employees, the good news is it would be covered under workers' compensation. Workers' comp does not require showing fault or liability or negligence on the other party. All you have to show is you're in the line and scope of your duties, and you were injured, and you're covered, and that will help with the medical bills of your son's thumb reconstruction. I believe, though, it sounds like it's a sole proprietorship with limited amount of employees. So if there's not 5 or more, you don't have workers' comp. If the defendant or the owner of the company does not have workers' comp, you're limited to a liability claim against that particular defendant. You have to show that he or she did something negligent that a reasonable, prudent person wouldn't do under those similar circumstances, and that he or she was negligent. It was the proximate cause of your son's injury. So the big difference in workers' comp, you don't have to prove fault, but in a regular tort case or tort claim, you have to prove that there was fault on behalf of a co-employee or your employer. And in this case, she didn't give us any facts to determine what the employer did that was negligent. So if you couldn't prove negligence, I'm sorry, but they wouldn't be liable in this situation.
Interesting.
Now there could be potentially a medical payments policy in play.
Okay.
True.
And so most insurances for homeowners, or in this case, even if it was on a business property where it happened, most of those insurance policies are going to have a provision for medical payments that'll pay dollar for dollar medical bills up to whatever the policy limit is. Now, most of the time that's only $5,000, but you do see sometimes higher limits of $25,000 or even greater that will pay dollar for dollar medical bills. And that's for if someone's injured on that property and you don't necessarily have to show fault. And so that is something that would potentially be available to him, but it would not help him with those 6 months of lost wages, which of course is a different story.
Yeah, that hurts. Okay, we've got Ricky on the line with a question. Thanks for calling. Ricky, what's your question tonight? Ricky?
My question is on the homeowner's insurance.
Okay.
I had an electrical storm back a few months ago, and I made a claim to the insurance company, and they sent me a check for $350. Well, I cashed it, and they sent me another check with my name on it and the finance company that I've got my mobile home finance through.
Okay.
And it done a lot of damage to my inside of my trailer, wall plugs and stereos and stuff like that, and it burned the stove up. Well, they paid me for the stove, but they didn't pay me for the rest of the stuff that's gone. I had an electrician come in and give an estimate on everything, but that's all that as far as it went.
Okay.
And I'm supposed to turn this other check into the finance company, but I just want to know what I can do about the rest of it.
Yeah. What do we do with this?
I think he's going to need a lawyer to help him sort through that.
Okay.
There's some questions there what those checks are actually for, right? And and this isn't going to be, your traditional policy of insurance either, because it is a mobile home. But you should be covered for an electrical storm, and but you may need a lawyer to help run some of those issues to ground. They're going to generally be responsible for anything that can be connected to that electrical storm. So sometimes what you see in these type of cases is they're arguing, well, look, there was already some damage there that we weren't responsible for, so we're not going to pay for X, Y, or Z, but we will pay for this over here. So you do have to be careful with them.
Oftentimes if you get a check like that, he mentioned it was made out to him and the finance company.
Yeah.
So if you own a vehicle, it gets damaged and you get a recovery, oftentimes the check will be you, and if there's a lien on the vehicle, or your finance company. In this particular case, if he or she didn't own their trailer and it was being financed and there was damage to that trailer, he mentioned there was 2 checks. But one check was to him and the finance company because they have an ownership in that particular dwelling. The $350 check made directly to the claimant, I'm unsure with a delta between those, but you got to be careful because oftentimes on that check it says full and final release.
Ooh.
And so I was expecting him to say, I cashed that check and then I was done.
Okay.
And so you got to make sure that check doesn't say full and final release. And then he had the question about it being to the finance company and him, and that's all about. They have an interest in that particular property.
Would that note be down in the memo area or on the back where you signed it?
It could be anywhere on the check.
Anywhere. Watch out.
That's
okay.
right. That's
okay.
right.
We have got a caller, Dwayne. Hi, Dwayne. Thanks for calling. What's your question tonight? Hey,
I
Dwayne.
was just curious as to why insurance companies take so long to reach a settlement long after, everything has been confirmed that they were, guilty. That person that they represent was, was the cause of.
Yeah.
That's a great question. That's a great question. And what William and I see it all the time is somebody's in a wreck, has a claimant, they try and get to you real fast, and they're all on it to try and resolve that case real quick. But if it can't be done quick and cheap, they transfer it to another adjuster, and then it's a long, slow process. And some insurance companies vary, but oftentimes it takes a while and it's not all their fault, a lot of it is. But a lot of times it takes, a client time to finish their medical treatment. Okay. Time to get all those records and bills to see exactly what the doctor opines is the nature and extent of the injury. We have to get that information, present that to the insurance company. If we cannot resolve the case, then we'll file a lawsuit. Okay. And then it's like taking a ticket at an ice cream stand to try and wait your turn to court when you get to try your case. It's oftentimes the longer it takes, Witnesses die, they move. Evidence is like water in the sun. It gets splashed around and evaporates. And so pushing it out as long as possible from an insurance company standpoint, because again, William and I have the burden of proof.
Yeah, it's on you.
And so it takes us 2-3 years. William, the jurors don't care as much. Oh, that happened 3 years ago. The guy sitting at the table.
He looks good.
Okay. I know he had all these surgeries, but it looks okay. And there's
The
not enough
wounds have
witnesses.
healed.
Yeah, exactly. So it makes a difference, doesn't it, William?
It does, and part of that is also this factor, which is insurance companies do not piecemeal out damages. They're not going to cut you a check every 2 weeks for the time you're missing for work or for your co-pays or something else. And so it's a war of attrition, and they're going to wear you down because they have big coffers, right? And so what they're going to do is they're not going to reimburse you any of your deductible at the doctor or copay. They're not going to pay you for your missed time for work. They're not going to compensate you for any of the things that you're going through during that process. And you're left to try and find a way to hold your head above water while all this is going on, with the hope that at the end of the day that you're going to get proper compensation for the from the insurance carrier for all the damages that you've suffered along the way. But they purposely do not pay out any damages along the way, so that you're left to try to fund that all on your own.
They're going to starve you out.
Yeah, and the hope is at the end of the process, you're like, you know what, I just want it over with. I don't care.
Take anything.
And unfortunately, when you're paycheck to paycheck,
yeah,
it gets real fast. Just because your wages aren't coming in doesn't mean your bills stop. The insurance companies know that. They could, by the way, pay it piecemeal, but they've set this standard that they don't, and that way it puts people in what we call the black hole of either workers' comp or tort claims, because again, all your bills are coming in, but your wages aren't coming in as well, and it gets real.
Gotcha.
It sure does.
Let's take a break. Be right back, answering more of your questions about fighting the insurance company. If you didn't get your questions answered tonight, here's how to get in touch with Will League and William Meservey. They are personal injury attorneys with Timberlake and League. So that's everything from car accidents to medical malpractice. 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon Doviet, family law, child custody, divorce, 539-7337, SharonFamilyLaw.com.
Thanks, you guys, for staying up with us and answering questions tonight. Just for people to know, how long do you have to file something? Statute of limitations.
In Alabama, it's 2 years. William, in Tennessee?
1 year.
So don't wait. Don't put it off. Thanks
right.
for your questions tonight. See you next week.